Oh, yeah.
Hello, that was me. That was me, everybody. My computer literally shut down, and so I am so sorry. I'm sorry, everybody. That was me. My computer literally shut down.
Nos disculpamos, la computadora de la anfitriona se apagó.
I am so sorry.
Me disculpo.
Back in. Everybody's coming
Ya
back.
estamos todos de regreso, estamos entrando.
Judy, you got to mute everybody.
Yeah. Okay, everybody. Hold on. I'm just getting people back in. Mute all. Hi, everybody. That was my fault. My computer literally crashed, and since I was the host, it canceled the entire thing. I was trying to prevent that from happening, but apparently I couldn't. Like, literally, it was horrible. So hopefully Katie's going to be back on soon.
Here.
Oh, yay. Katie,
yes.
There's nothing to do with you. My computer literally shut off. I don't know why. It just shut off. So please go back to sharing your screen. I apologize, everybody. And I'm going to make sure that Ed is the co-host so that if she is the co-host. Good. So that if it happens again, you will not be thrown off.
Okay. And you need to enable screen share.
Oh, yes. Here we go. Done.
Judy, I just want to mention real quick that I was co-host last time, so you might want to consider making me host.
I'm making you host
right
now. Okay.
Okay. So, fair hearing process starts with an informal meeting, and this is voluntary. You can participate in it. You don't have to. There's actually a checkbox on the form where you indicate if you want to. It's a meeting with the director of the regional center or someone acting on their behalf. In my experience, it is always someone acting on their behalf. I've never had a regional center director actually show up to an informal meeting. And so that meeting has to be held within 10 days of your request. You can bring other people to that meeting with you. It's an opportunity to negotiate is really what it is. Following the meeting, Regional Center will send you a letter explaining whether it is keeping the same position, if it's going to offer you something different, what have you. At that point, you can withdraw your hearing request if you feel like the issue has been settled, or you can move forward in the hearing process. You know, it all depends on you whether you want to participate. I've had a lot of good luck at informal meetings. I've talked to other people who don't want to participate in them because they don't feel like it moves the process forward. I think particularly where there might be more information to share, those meetings can be very helpful because, you know, sharing that additional information could result in a changed decision. The next step in the process is mediation, and that's a meeting between the parties with a neutral third party. The Office of Administrative Hearings assigns a mediator to the case. It's a judge. It's not the judge that will be assigned to your case. Mediation is actually voluntary for both sides. So the informal meeting, if you want one, the regional center has to do it. But mediation, even if you say, I want to do mediation, the regional center can say, we don't want to do mediation, and then it doesn't happen. There are a number of regional centers who just very, very, very rarely will do mediation. And what many of them have said to me is they don't feel like it reaches resolution in their experience, and so sort of why waste everyone's time. The third and final step in the process is actually an administrative hearing. You know, it is a hearing, and so, but it is not like Judge Judy. It's not held in a courtroom, it's held in a conference room. And right now they're not even being held in conference rooms, they're being held via Zoom at your home. So you sit on your couch. You know, when they were held in person, you would go to the regional center. They were typically held at the regional center, occasionally not, but typically at the regional center. You'd go into a conference room, administrative law judge sits at the head of the table, you sit on one side of the table, regional center sits on the other side of the table. The Office of Administrative Hearings is operated by the Department of General Services. So they're a state department and they do the hearings. The Office of Administrative Hearings also does special education hearings. They also do a lot of licensure hearings. They do medical board hearings, things like that. So they do lots of different kinds of hearings. You can have an attorney or advocate attend with you. You don't have to. I will tell you, the bulk of people who do regional center hearings do not have an attorney or advocate with them. It's actually pretty unusual when you read the hearing decisions. That being said, the regional center can also have counsel. Most regional centers have staff members that represent them regularly in their hearings. At some regional centers, that staff member is a licensed attorney, at a couple of them. There are also a couple of law firms out there that regularly represent regional centers. And so the regional center can contract with them to, you know, to have representation on certain matters. You know, the idea of the process, you know, all of you know me, I tell you what I think, can't help it. The idea of the process, the way it was designed, the idea was that families and parents and consumers wouldn't have to have attorneys. I will tell you, it is getting increasingly complex. Even 20 years ago when I started doing them, I feel like they were easier than they are today. When you compare them to, say, a special education hearing, they're a piece of cake. The average special ed hearing lasts 9 days. The average regional center hearing lasts less than a full day. So they are still much less complex than special education hearings. I think they are more complex than, say, an IHSS hearing. You know, the reality is that there are no fee provisions. So in special education, if you prevail at hearing, your attorney can collect fees from the school districts. That's honestly why lots of attorneys do special education cases. That is not true of regional center. I'm an attorney. If I represent you and we win at hearing, yay us. But I don't get to collect any money from the regional center. You still have to pay me, right? So think about a lot of the things that you would go to hearing about with regional center. If you're going to hearing for an increase in respite, well, you're gonna pay me to represent you more than the cost of buying more respite, right? And so there are no attorney fee provisions, and for a lot of the services, an attorney would cost more than the service. That's why there are not a lot of attorneys that do these cases, and the bulk of attorneys that do them are people like me who get paid through, I work for a nonprofit, I work for Disability Rights California. We have a contract with the Department of Developmental Services, and that's how I get paid. Individuals don't pay me. The bulk of people who do regional center hearings fall into that category. There are a handful of private attorneys that do them for pay, but not a lot. So, okay, so the hearing must be held within 50 days. For children over 3, if the child's under 3, if you're talking about early start, it's within 30 days. Those timelines, because of COVID, have not been happening at all. Although what we're hearing from the Office of Administrative Hearings is that once they sort of admitted that they weren't going to be doing live hearings anymore, that they're getting back on getting people on calendar and moving things through. I think that they were like a lot of us and hoped, you know, back in March that we were only going to be home for a month or two and then the world would go back to normal. And if we, you know, and then it occurred that we were not getting back to normal anytime soon and they were just going to have to do things differently. So 5 days before the hearing, you have to exchange with the regional center a packet of information that includes a list of your witnesses and the general subject of their testimony. That's one sentence. So if I'm going to call Connie to testify about my need for support while I take an educational class, I'm going to write Connie Lapin, family friend, to discuss need for support. If I am going to call one of my doctors to talk about a physical need that I have for a piece of equipment, I'm going to write, Dr. Bob Smith, will testify to my need toward an adaptive bicycle, what have you. So one sentence about general subject of what the person's testifying about, and all documentary evidence that I want the judge to consider. I'm going to send one of those to the regional center. Regional center is going to send me one of those. I'm also going to send one of those to the administrative law judge. So in the old days, that was literally a packet that I would FedEx, overnight mail with signature, and that I would get from FedEx. Nowadays, that's all done electronically. It actually makes it a little bit easier. And you really, when you get that packet from Regional Center, you really want to review that and their witnesses so that you're prepared to respond to that. So then the day of the hearing, you show up, or in today's world, you log on. The administrative law judge opens the case, will explain the process, how things are going to go. That person will then go over your witness and evidence lists. If you want to object to a piece of evidence that the regional center is submitting, this is your time to do so. And what you would do is you would tell the administrative law judge that you object to that and then explain why you don't think it should be included in the packet and that the judge shouldn't have access to that document to base their decision on. The same thing is true for regional center. They can object to anything that you've put forward. In my experience, the administrative law judges really want more evidence and so tend to let a lot of things in. And then the administrative law judge will ask for opening statements and clarify the issue. And that's because sometimes it is sort of interesting because you read what the family wrote on a hearing request and you read what Regional Center wrote in the letter, and those two don't exactly match. And so sometimes the judge really has to spend a good amount of time figuring out what the issue is. And I think this is where the fact that self-determination is new, I think this issue development stage is going to be really crucial. And so I would also be prepared to, at that point, give a little bit of background on the program so that the judge understands that this is different than a traditional regional center case. We're in a new program now. And so, really clarify that issue. Next up, the regional center will present its case. They're going to call witnesses. And so the regional center always goes first unless you make other arrangements. They'll call their witnesses. They'll question their witnesses. You then have an opportunity to ask their witnesses questions. So I will tell you, this is not Judge Judy. This is not Perry Mason. I live by the rule of I don't ask a question I don't know the answer to. And I do not have this real deep plan that I'm going to catch someone in a lie and I'm going to expose them like Perry Mason. In real life, that rarely happens, right? And so sometimes it's actually better to just not ask the question. You know, and I've heard people say, well, so-and-so's lying. Well, unless you can prove through documentary evidence that what they're saying at the hearing is not true, to some degree, there's not a ton you can do about it, quite honestly. If you have documentary evidence to the contrary, then you will want to pull that evidence and show it to the judge. If it's something where you might have additional information, you can ask the judge to what's called keep the record open for you to submit additional information to demonstrate that the person, you know, was saying something contrary to what they have said before. But I would be careful with thinking that you're gonna create this gotcha moment, because I just find in real life those don't happen much. So after the regional center presents its case, it's your turn. So you can call your witnesses, you can testify yourself. You do not have to do something creepy where you ask yourself questions. You can just speak in the narrative. My other piece of advice, do not think that you can wing it. You can't. I will just tell you, you can't wing it. Write out something in advance. If you're very accustomed to public speaking, I think you can just write bullet points. But practice, practice, practice if that's all you're going to do. The reason that I say that you're not going to be able to wing it is because you're going to be very nervous. And when the nerves get the best of you, it becomes much more difficult to wing it. So do not plan on winging it. I implore you not to. What will happen is you will forget to say something really important. So write it all out. Have a good plan for yourself. When you call your witnesses, you will ask them questions. Both with all witnesses, you can direct them to evidence. So if someone's talking about a report that they wrote, you can direct them to that report. You can have them read quotes from that report. You know, if there's helpful information in a document, you can have someone read that, have them read that paragraph from that document, and then ask them, you know, to interpret that paragraph, or if it changes their mind about something or makes them believe something. The regional center can cross-examine you and your witnesses. After all of that testimony is finished, the administrative law judge will ask for closing arguments. Most of the time those are done orally. I will tell you, people like me, we like to irritate judges, and we really don't like to be irritating, but we often ask that we write a written closing brief instead of an oral closing. Some judges don't like that because it prolongs the process and they want to finish this. Other judges are fine with it. I've never had one deny my request, but I once had a judge tell me that all I could turn in was a 3-page written brief. You can tell from this 14-page document that I'm going through today, I don't do anything in 3 pages. So that was like the hardest thing I've ever written in my life. But I've never had a judge tell me I couldn't do it in writing. When the hearing's over, then the judge issues a written decision, and it's supposed to be within 10 days. I have had a lot of occasions where the administrative law judge asked for additional time. That's especially true where there is a lot of documents or a lot of records. You'll get the hearing decision in the mail. So the day of hearing, once again, this is not like a TV show. It's very anticlimactic. It ends, especially now that they're all via Zoom. You click leave meeting and it's over. And then you go cook dinner for your family, right? There's no big exciting gavel thumping, you win kind of moment. You'll get certified mail. You'll get the hearing decision. I will tell you, I've trained myself to look for the second to last page because that's where it will say the appeal is granted, the appeal is denied. The very last page is who they sent a copy of the decision to. So it's the second to last page that you care about. And that will tell you whether you've won or lost. I will say that the judge, it is not always as simple as win or lose. Judges can issue what are called split decisions. So particularly if there's more than one issue, I want to increase my self-determination budget because I need books for my classes and I need someone to go with me to yoga class for my exercise routine. The judge could say, yes, they have to increase your budget for books. No, they don't have to increase it for a personal attendant to go to yoga with you. A judge, so they can split. You can win on one issue, lose on another. I've also seen hearing decisions where a certain number of hours was requested. Someone wants 40 hours a week. And the administrative law judge found that they did not prove that they needed 40 hours a week of that service, but instead demonstrated that they needed 25 hours a week. So there is some flexibility that judges have. They have to justify, with the evidence that they had, why they're making their decision based on the evidence and the law, but they can do what are called split decisions. If you win, the regional center must implement the decision. Regional center can appeal the decision, just like you can. Whoever is not satisfied can appeal it to Superior Court. I will tell you very, 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 very few regional center decisions are appealed to Superior Court. Very, very, very few. It's very unusual. So that's the hearing process. When you think about how you're going to prepare, it's really gathering information. And one of the things that I think is different with self-determination, because I think most cases are going to be around budget increases, is, you're going to have to demonstrate how much that service is going to cost. And so you're going to need evidence about the cost of that service that you need. And that's not something that we've really had to do before, because when you're using vendored services, it's just, I need that service or I need that vendor, what have you. Cost doesn't really come into it. But with this, because you're going to be requesting a change to the budget, you're going to have to demonstrate that cost. I think particularly in situations where you're looking for what I call like a static cost, like I need a piece of equipment, I think if you can get evidence from multiple sources of the cost of that piece of equipment, that's really important to do, because then you're demonstrating that what you're requesting is really an average cost, a typical cost. And so I think it's important to get evidence of that cost from multiple sources. I think it's important that you explain how you came up with that cost, particularly if it's not what I call a static cost, a piece of equipment. Here's a screenshot of a website that has it for sale for $54, but if it's an ongoing cost, a personal attendant, here's the number of hours, here's the wage the person needs to earn, here's the additional costs associated with employment costs, here's how much that person will cost over time, the duration of time that I need them. So you really need to demonstrate those costs. Prepare. That includes preparing your witnesses. You can look up prior hearing decisions. Everybody can go on right now. You go to the Office of Administrative Hearings, Department of Developmental Services hearing webpage. You can click on hearing decisions, and then in the search engine, type in self-determination, and you can get all of the self-determination decisions, and you can read all of them. I encourage you to do that. That gives you an idea of how judges have ruled on these cases and what factors they considered to be important. You can also learn about your administrative law judge. You can read decisions that that judge has issued before. If you read a bunch of decisions and you believe that your judge that's been assigned to your case is biased in some way, you can ask that that judge be recused and that another judge be assigned. It's a very simple letter that you write. We have a copy of it in our we have a publication about regional center hearings, and that includes a sample letter for that. Those prior decisions are not binding. They're not like Supreme Court decisions that now every court in the land has to follow. But I sometimes, particularly if they are very similar to my case, or very opposite of my case, I might include them in my evidence packet, not as evidence, but just so that the judge can take judicial notice of those, just so the judge can see how other judges have considered these issues. I also encourage people to connect with other people who have done hearings. Groups like this, I think, are really important. So you can talk to them. Oh, you had that judge. How did it go? What kinds of questions did he ask you? Because the judge can ask questions too. You also want to look up the actual law. So, you can get the Lanterman Act and the implementing regulations on the DDS webpage. The Disability Rights California webpage has lots of good publications. Like I said, we have one all about regional center hearings. We have one all about respite hearings. I encourage people, if you're going to be going to hearing, to review those packets because they include a lot of sample documents, which are very helpful. If you have questions, you can call our legal advocacy unit. I know one of our senior attorneys from that work group's on our call today. You can also call my unit, the Office of Clients' Rights Advocacy. We've got one of our CRAs on the line. State Council also has a lot of information about regional center hearings, so they're a good resource for you. And then finally, remember I said I want to talk about language access real quick at the end. Regional center must communicate with you or your family in your native language. That's true during the planning and development of your IPP, at your meeting. They have to provide you a copy of your IPP in your native language. They have to give you your notices of action in your native language. They should be documenting in your IPP what your preferred language is. And if those things are not happening, you can file a complaint under Section 4731 of the Lanterman Act. And those complaints go to the director of the regional center. The regional center director normally has 20 days to respond. That's been extended because of COVID. If you're unsatisfied with that response, you can then appeal that to the Department of Developmental Services. I'm big on language access. I think understanding is really the very beginning of your rights. And so if you can't literally understand, how are you going to advocate for your rights? So I think that's really important that families are really clear with their regional center, what their preferred language is, and to request information and communication in it. So that was the quickest version of fair hearings, but I wanted to allow a little bit of time for questions.
Yeah.
But I will tell you, really, we could spend a whole day, and I actually do a training that's a whole day long, and we actually do pretend, we do little mock things. It's really fun. I mean, let's be honest, I have a warped sense of fun at this point in my life.
It's
and
not
really,
Disneyland.
you know, anything that would allow me to be with humans again, I would consider fun at this point. But, you know, so really we could spend a day or two talking about regional center hearings, but you got the hour version, so.
So if you could stop sharing screen so we can see everybody. I just first, once again, want to apologize for kicking everybody off. It was my computer. We have a grant proposal due. And so I had everything up on my screen and my computer said, hell no, and shut down. So I apologize. But let me tell everybody how you can ask a question or make a comment. You go down to participants and you will see your name and you will see an option to raise hands. I already have a couple of people who've raised their hands. And it keeps the order, so don't think that I'm like calling on somebody before you raised your hand. If for some reason you're having a problem finding the raise hand feature, you can put something in the chat that says you'd like to ask a question.
And I saw one person in the chat ask if they could get a copy of the thing I was scrolling through, and Judy has a copy of it in English. I'll be honest, Judy and I put this together on Monday, so it is not in Spanish yet because I didn't want to like freak out my staff who translate things for me by saying, can you have this for me in 2 hours? But we can get it in Spanish so that and I can get that to you, Judy.
I really appreciate that, Katie.
Yeah.
I have like 500 questions based on your presentation, but I'm going to let everybody else talk first, and then if maybe they'll be asking me the same question. So we're going to start with Fernando at the ICC. Go ahead, Fernando. You can unmute yourself.
Okay, thank you, Judy. Katie, good to see you, and thank you so much for a very informative presentation, and actually very timely presentation. We have been spending a lot of time what we're lovingly calling the unfair hearing process, not necessarily the fair hearing process. And so I have a couple of comments and a couple of questions for you. One, we know that the school system has, as you mentioned, a program in place on representation, and being in a similar situation where the regional center system and the individuals that are served either through the school system or through the regional center system, we don't see the difference in why there shouldn't be a program similar for the regional center system where attorney fees are covered for that representation. And the reason I highlight that point is that because, as you had alluded to in your presentation, the fair hearings that usually last half a day, and they're definitely not a Judge Judy or Perry Mason, it really not anything anywhere near what we are experiencing. We're seeing that hearings last on the average of 2, sometimes 4 days. And it's really a bad character representation of a Perry Mason, and for many reasons. But for the key reasons are that the regional center has staffed up really well, whether either through that attorney representation or that third party law firm or that individual whose expertise is in law to then represent their interest in a hearing. And when we bring in a family to that hearing process, in many cases, we're looking at Latino families who are already dealing with disparities and the cultural challenges. And for everyone, I mean, I don't know if anyone here in this presentation is thinking about going to a fair hearing, but you can't wing it. I mean, you're not kidding on that. You have to be so prepared. You have to be in a position that, I mean, I bought a car, I know how to drive the car, but don't ask me to be able to fix the car because, you know, you're an attorney and you know exactly how to fix that car if you were, you know, the equivalent to a mechanic, because that's your expertise. But for just a layman, person like us, it really is over the top experience. And I find it in many ways demeaning, degrading, and really unfair because we're seeing individuals really come after the family. When they go through that process of mediation and so forth, and the regional centers obtaining all that information to try to resolve an issue, and it doesn't get resolved, it goes to the fair hearing, they are using that information against you. So they're already in a position to kind of stack the deck against you. So we're definitely not seeing anything fair about it. And my question to you would be, you know, when you look at the administrative law judges that are available, and everyone that we've come across are all Anglo, all right? I don't see any diversity at all. So are there any prerequisites to have some type of diversity representation within the law judges? And also, what about outcomes? Do we know what the outcomes have been by ethnicity? And I don't know, even just the last year. I'd be curious to see how that plays out. And also, what would outcomes be if a family has legal representation on their behalf to one that doesn't? And those sound similar information. And the reason I bring this up is because I firmly believe, based on what we're seeing, that there is a high degree of disparity that are generated through this process. I apologize for throwing a lot at you, but this is, like I said, something that's been top of mind, something we're dealing with. And I think systemically, we have to look at it and see how we can fix it.
Yeah, so I will tell you, in my sort of, you know, who I have appeared before, I have appeared in front of judges of every ethnicity, and both men and women. You know, for many years, we had an administrative law judge who had left DRC, Danielle Juarez, who was an administrative law judge doing regional center cases for many years. It is, I mean, I will tell you, the legal profession is still white, and so that's where judges come from, is from lawyers. And so it, you know, I suspect that it is, I don't suspect, I mean, I say with confidence that that they are predominantly white. Partly because, like I said, that's where, you know, it comes from lawyers, and lawyers are still more white. So I do not know of a requirement that, you know, in regards to diversity. They are a state agency, so you know, there may be some related to their contracts. In terms of outcomes, they publish a report to the department, I believe it's annually, around the number of hearings filed, whether those, what happened to those hearings, were they withdrawn, did they go through the entire process that resulted in decisions, how many decisions were for the claimant, how many decisions were for the regional center, how many were split. I do not recall seeing those divided, you know, by ethnicity of the claimant. I don't remember seeing that in the data that I have seen. Yeah, I don't. I mean, honestly, I read those reports like once a year, but I don't remember ever seeing ethnicity as part of that report.
Katie,
and Robin,
yeah, in the chat that there is a new requirement effective January 2020. Were you about to talk about that?
Yeah, so starting this January, DDS is to report the ethnicity information regarding fair hearings. And regional centers were just required to submit it for the fiscal year that just ended in June. And so the person commenting, and you know, Robin can certainly you know, speak to this, or you know, I know Christine's on, we've got a couple, you know, and Amy's on, we've got some regional center folks too. I know some of them have already done that reporting at their board meetings, or, you know, consumer meetings, but it's not, it's just starting. So I don't know of, I have not seen any yet. So I think, you know, at the regional center that you're at, if you're interested in that data, I would certainly be asking about it. You know, we've just finished the purchase of service data meetings. And I think, you know, those are all good questions to ask. And I know, Fernando, you and I were at one of those meetings together, and you brought this issue up. So I think certainly worth continuing to talk about.
Thanks, Katie. We have a lot of questions and not a huge amount of time. So I want to get to everybody. I'm going to ask that you keep your questions or comments to just a couple of minutes. I'm not going to cut you off, but I just appreciate it. Connie is next, or Harvey maybe.
Yeah, Harvey.
A 2-for-1 sale. Hi, Katie.
Hi.
I have a question, a point of information. How many fair hearings have there been in self-determination? Do you have that number?
So of the ones that I could find in sort of what I call new programs, so aren't for people who were in it and before, and even there's a couple of hearing decisions that are recent, but they're people who've been in self-determination for 20 years, and the transition into the new program has been a little rough. If you don't count any of those, I found 3. But I know of a number of people who have hearing dates coming up.
Oh, you don't.
What were the outcomes, Katie?
So it's interesting, and that's why I brought up that whole idea of split decisions. There was one that was a total loss. They did not agree with the claimant on anything. There was one that was a split, 2 that were splits, and 1 that was a total loss.
Oh,
Okay, a point of information for everyone. There was only 1 fair hearing in the pilot of approximately 200 people in it over all the years. That's the information I have. And as far as legal fees, to my younger brother and sisters on this, I tried that 30 years ago with Assemblyman Richard Katz, that if you prevailed
In the regional center.
in a regional center system in a dispute, you got legal fees. That's for you guys to do. That is a just type of legislation as far as I'm concerned. That will level the playing ground. And that's basically it. Thank you for the information.
So it's good for everybody to know that, you know, Fernando's concerns about the fact that in the regional centers, families who prevail cannot get their attorney's fees paid for is something that has been tried for decades, and we haven't been able to succeed. Probably now is not the best time to ask for that because of COVID, because of the probably really significant budget cuts that may be coming our way. But it's on my to-do list, that's for sure, someday.
Judy, I just want to chime in for 1 second. I know we haven't done a couple minutes, but when you're looking at outcomes, Fernando, I love all your questions and comments. I remember when they first started giving the data when I was on a regional center board, and the regional center was bragging, they resolve it right with the executive director, and there's just no problems. So when you looked for how many fair hearings there are, that is not an indicator of all the problems, because people, just like Katie said, you don't get attorney's fees, and more important, you're scared, and you don't have the time, the energy, the wherewithal to file. So we have to be very careful when we look at outcomes, because some regional centers present this as, look, we're doing such a great job, there's hardly any fair hearings.
Yeah. Thank you. Okay, we're moving on to David Oster. Hi, David. Go ahead and unmute yourself, David.
Yeah, I had a question. If you don't win the first hearing or fair hearing, can you win the next?
Yeah, so, you know, if you go to hearing and then circumstances change or you have new evidence, you can make that request again. And if it gets denied again, then you can go to hearing on it again.
Yeah.
But it wouldn't really be worth it to go to hearing again unless you had new information or different evidence or something in your life changed.
They say a closed mouth doesn't get fed. I've learned that.
That is
And-
definitely true.
And then can you mail me the packet of all what you showed me to the mailer?
Oh, yeah. The thing on my screen?
Send it to my address.
Yeah, I'll send it to you, David.
And so everybody should know we keep, and I'll ask Ed to put it in the chat.
I got all the.
Yeah, thanks, David.
I got your book.
Thank you, David. We keep all of the recordings of our SDP Connect, and tonight it will be 2 recordings since I hung everybody up on our Interchange website. So you'll see it in the chat, or you could just find it if you go to disabilityvoicesunited.org. It has links to the Interchange on that. And what we'll do is right next to this recording is we'll put the Katie's presentation, so you'll be able to get access to it. All right, Sunny, you are next.
Sunny.
Thank you. Hi, I'll be super quick. So my question is, I'm encountering some situations where it doesn't result in a notice of action, or the regional center it's like delays basically. So there is no notice of action. There's just no action at all. And is there any, do people have any rights in that situation, or what can be done when, you know, you've been going back and forth with the regional center on like a budget is the big one that a lot of people are stuck on for months. And so there's no like decision from the regional center either way.
Yeah, so I mean, I think, you know, it's interesting, you know, if you read the statute for self-determination, I believe it is 8 pages. And, you know, we invented a whole new service delivery system in 8 pages. And this was the whole idea of doing 2,500 people, you know, for the first 3 years, was to try and kind of figure out some of the bugs. And I will tell you, I think one of the things that when I look back, I think, ooh, we should have done that, as we all do in life, is timelines. In hindsight, I probably would have put timelines in self-determination, and we didn't do that. And, you know, so we still have the regular land term and timelines that I think still fit in many scenarios. And so in the IPP process, when you have an IPP, if you can't reach resolution, you can take 15 days. And because think about it, in an IPP, there's a lot of times where people have to gather more information. The regional center may need to go talk to vendors or to a committee. The family may need to talk to a doctor or what have you. And so the law provides for 15 days, you know, as an extension on an IPP. And I would try and use that as a framework, even within self-determination, because even though we're not doing a traditional IPP under 4646, which is the statute that talks about IPPs, I think it's very comparable. And so, but I think good practice is to set that out at the beginning. So when you begin your negotiations, say, my expectation is that we have this resolved by this date. And then it is best practice to get a notice of action. It's best practice for regional center to give you one. But like I was saying, sometimes there really is confusion about whether there's agreement or not. And so you can actually file for fair hearing without having a notice of action. And I will tell you, there are times that I have filed without a notice because, and what I say in my letter is, I ask for this on this date. I ask again on this date. I ask again on this date. Here we are, I still don't have it. That means it's been denied. And so I need to move forward in this process because clearly we're not able to resolve it through informal means. And you can use the hearing request form to do that, or you can even, you know, just write a letter. I would send it to the regional center. If you know who the fair hearing director is at your regional center, you can send it directly to them. If you don't, just send it to the executive director. They can route it to the executive director of the regional center and to the Office of Administrative Hearings, to both. And so like I said, it is best practice, and I always hope for a notice, but ultimately, sometimes you just have to file because you need to move things along.
Thanks, Katie. I was talking and muted. So now I'm going to ask Lorna to ask for any questions on the Spanish line. So while Lorna is asking that, I'm going to do a promotion unrelated to this of the Disability Vote California Coalition. This is a coalition of organizations around the state of California who work with people with disabilities, who represent, who advocate for, and who want to ensure that people have the right to vote, have access to voting. Disability Rights California is part of it, as well as many of the groups that are here on this call. We have webinars every week, and tomorrow, it looks like there's no questions. Okay, tomorrow we are having a webinar on
Mañana sobre votación.
Oops. Okay. We are having a webinar on how politicians talk about disability and race, and how that really matters. So if you are not on our mailing list and have not been seeing this information, I'm going to ask Ed to put on the chat how to join our mailing list so that you get notifications for our webinars. All right, we're going to move on. Somebody was on here and now she's gone.
I'm sorry to interrupt, Judy, but I do have in the chat Carla Lehman saying Martha has a question in Spanish.
Lorna, Lorna, was there a question in Spanish? They need to make sure they're not muted in.
Judy, I unmuted the Spanish line and there was nobody. I mean, I will unmute again.
Carla, can you type in the chat where you're getting this from, please?
They texted me.
Is she listening in with Lorna?
Let me ask her.
All right, I'm gonna go, we will definitely take her next. Okay. Unless Lorna starts waving at me that she's talking to her, okay?
Okay.
All right, so there was somebody else, Lori, somebody, but she is gone. So we're gonna go to Christina Canarella.
Hi, thank you for the presentation. It's really helpful to learn all of this for people who have never gone through this before. My question is that if we start to find a pattern where consumers are having the same, running into the same problems, not getting services or being denied services, is there a way to do a fair hearing collectively, or what would constitute more of a class action or collective, thing to go to a hearing to try to get, if there's patterns, whether it's within the same regional center or within different regional centers, but it's the same issue.
Okay, so I'm also going to warn people there's a small gnat flying around my office. So if you see me swiping, I haven't just kind of lost my mind. There really is a small gnat flying around. But so you can do what's called consolidate hearings. So let's say that I've asked for something, Judy's asked for it, you've asked for it, Christina, they've denied all of them, right? We're all asking for the same thing, really the same reason. We can consolidate our hearings because our evidence is really going to be the same. What makes consolidated hearings challenging is because, remember, services are individually driven under the Lanterman Act. And so a lot of our evidence has to be why I as an individual need this service. And so that is going to be different between the three of us. But the bulk of our evidence might be the same. And so it might be that we do all of the same evidence together, and then I do like my little piece just for me, you do your little piece, but we've consolidated those hearings. And so so you can do what are called consolidated hearings. I have never heard of consolidating hearings against multiple regional centers. I have read a handful of hearing decisions that were taken up against 2 regional centers when the dispute was around moving from one center to the other. And so both centers were named to defend it because it really was about that transfer. But I mean, that's reading literally a handful over many years. And so I think involving multiple regional centers with multiple parties, you start getting into there are more and more differences, and it is less likely that the Office of Administrative Hearings would want to consolidate those because it starts making them seem less similar. And so what you would do is, you know, if it's you, Judy, and I, we would send a letter to the Office of Administrative Hearings, CC our regional center, explain why we want to consolidate the hearings, list all of our hearing numbers, and that's how you would proceed to consolidate.
All right, thank you very much. And how, part of can we be part of the mock trial that you were talking about that you did?
So, you know, so I do lots of trainings over the years. You know, OCRA staff do lots of trainings. You know, we just finished a big training series that was done all in Spanish over 7 weeks. You know, we offer all different trainings. If you have a group that wants a fair hearing training, you know, reach out to me, reach out to your local client's rights advocate. You know, we can put some of that together. It's a little more challenging virtually.
Thank you. There's a question from N. Steve. Is the name that's coming up?
Yep, that's me. Can you hear me?
Yes.
Hi. Thank you so much for this talk. It was amazing, and it opened up a lot more questions. I am going to a fair hearing in October, possibly, unless I cancel it. What you said was very interesting about the, oh gosh, what do you call it when you get a letter? The award letter?
Action.
Thank
The
you.
notice of action? Uh-huh.
Correct. Well, there's a series of interesting things because what I'm going for is they are denying a service that he's had. And what they said was, well, he can't continue with this service because it was out at limited time. So that bothered me that it was a limited time and I never got a notice saying his service is over. So then I'm curious as to what kind of, you said evidence, you need evidence. Well, the evidence is that this person is requesting the situation to continue because he's benefiting from the services, but it's a personal service. How do you consolidate evidence from what the client is asking for to get help and continue the service? What type of evidence can a person get?
Right. So when you think about evidence, evidence can be a document, a report. And so in some cases we have reports that we have that show, you know, if it's speech therapy, he had this many words, now he has this many words, right? So it could be a report. It can also be testimony. So it could be, I go with David when David goes to the gym because he needs me to support him and guide him on using the equipment, right? Or in real life, it would probably be the opposite where David was assisting me. But so David could testify that he has to help me because when he goes with me and he tries to back off and have me use the equipment on my own, bad things ensue, right? So he tried, he said, Katie, I want you, you know, we've done this every day for a week. Now you try it on your own. I tried, I got injured, or I couldn't do it right, or what have you. So that's going to be testimonial evidence. And so I don't have a report that says that, but I'm going to testify. And so in some situations, there's not a piece of paper that says it. It is a person who's going to say it based on their observations.
Does the Letterman Act anywhere say that a person can have only limited amount of time of a service, or is it the person who is receiving the services feel that they're done with the services because they've done all that they can with that service, or that things are evolving and continuing evolving and the service is still needed?
So there's nothing in the Lanterman Act that talks about a service being time limited or not. Because remember, the whole basis of the Lanterman Act is it's individually driven. But I will tell you, when I was a CRA, there were a handful of services that were, more popular 20 years ago that were sort of by definition more time limited and were more typically provided only for certain amounts of time. But we could still, even in those cases, demonstrate that the person receiving the service needed it longer. And particularly in cases of, where it was related to their disability, that their ability to generalize information to new environments might be impaired. A person might need longer, to do that. And so it really is, there's nothing in the law that says services can or can't be time limited. It really is about the individual. And so you really want to go to what facts make it so that this person still needs this service.
Okay, that's wonderful. Thank you.
So right now I'm just checking in with our interpreter who's only booked until 6. And I just want to see, she can only do another 10 minutes. So we have a hard stop at 6:10, everybody, because we are committed to having everything on our SDP Connect translated into Spanish. So I'm going to ask, I'm not going to take any more questions after the 3 that are up here. So please, no one else raise your hand. And I ask each of you to just ask your question very quickly. So Vianney Gomez is next.
Yes. Hi, my name is Vianney Gomez, and I'm actually about to go to a fair hearing, and I wanted to see what kind of legal representation can Katie provide as far as supporting me, since this is on you.
So, I'm actually the director of the program. So I actually am sort of useless to all of you at this point. I don't practice anymore. And so, but we have a client's rights advocate for each of the 21 regional centers. And so what regional center are you at, Vianney?
Harbor Regional Center.
Okay, you're at Harbor. So actually our regular advocate is out on leave right now, but we have an advocate named John Anthony Alamo, and I'm gonna put his name in the chat for you and his number.
Okay.
Yeah, I think that's a really important question because honestly, this seems like a very intimidating process. And I think I think it's a lot to ask for families to do this on their own, especially when going up against regional centers. I'm really concerned. Sania, you're next. Go ahead and unmute yourself, Sania. There you go.
Thank you, Judy.
How are you,
Judy?
Sania?
I'm doing.
Yeah, I wish you well.
By the grace of God.
It's a difficult time we're in, yeah.
Yes. My question is, I have a list of vendors for services, and some of them that I wanted to include in the budget for the self-determination program includes attorneys. But I'm hearing from you all that attorneys are not paid for. And I wanted to know why do they have attorneys fees or an attorney's fee schedule included in the vendors list that we can include in the annual budget for self-determination if they're not going to allow a payment for those attorneys? I'm kind of confused on that. And then secondly, I wanted to know, what is disability rights doing about this? Because even in civil court, there's an opportunity to go to small claims court where there's no attorneys for anyone, where people are on equal playing field. So why is it with people with developmental disabilities that they have to fend for themselves. And I hear a referral to an advocate, but I would like to know, where is disability rights on this? Why aren't they stepping up, since they're already being paid to represent some of these clients in fair hearings?
Thanks, Sonia. Great
Yeah.
questions. Really great
So,
questions.
yeah, so the first question, so when we were talking about that there's no attorney fees, that's for if you go to hearing and prevail. And that's different than why there's an attorney fee schedule in self-determination. So regional centers can pay for attorneys not to go up against them, but for other kinds of advocacy. So for example, a million years ago, because especially days like today, I feel really old, so it must have been a million years ago, I was a regional center vendor doing special ed cases. And I actually worked for a regional center. This was literally like 25 years ago. And they paid me, and I represented families at IEP meetings. And so those are the kinds of attorneys that you can get paid for. There are a handful of regional centers that I think still pay for advocates to help families at IHSS hearings. So that's where that fee schedule comes in, and some examples of the kinds of attorneys that could be paid for by the regional center. I do not know of a case where the regional center paid for an attorney or advocate to represent a family in a proceeding against the regional center.
Where, Ms. Hornberger, where can I find the written stature that specifically says what you're saying? Because it's a general list, and it doesn't specify that they pay for attorneys for this or for that. It just says they pay attorney fees.
Mm-hmm. So, I mean, you can ask for anything. I will say you can ask for anything. I have not heard of a family being successful in getting regional center to pay for an advocate to fight regional center.
So here's what I have seen, and it's only one time, Sonia, that I've seen this. Is I have a friend who went to fair hearing, won at fair hearing, but the regional center appealed it to Superior Court. The Superior Court judge, and so they got a pro bono attorney to represent them at Superior Court. The Superior Court ruled in favor of the consumer, of the individual, against the regional center, and found the case to be so egregious that, and in the public interest, that they required the regional center to pay for the attorney's fees. But that's the only time I've ever seen that. I'm sure it's happened. Yeah. I know that's happened a handful of times with Superior Court cases.
Right, and that's,
I'm not asking my question about after the fact, and I apologize. I'm not trying to take up all the time, but I think there's a misunderstanding of my question. I'm talking about for self-determination, when you put in the budget and you try to get unmet
plan.
That's what I'm talking about.
I get it, Sonia. Yes.
Putting attorney in the budget and wording it in such a way that it's an unmet need, because it's been an ongoing need for years, that it's included in the budget as an unmet need.
So remember that unmet need can only be claimed by what is offered in the traditional system. But if you're not, if this has to do with not increasing your budget, but just putting it in the spending plan, like you already have the money in your budget and want to put that service in your spending plan, you do have a right to do that. So there's a difference between asking for your budget to be increased for the service of hiring an attorney, which is not something that would be paid for in the traditional system. But if you have the budget for it, you can put it in your spending plan. There is advocacy in the spending plan, or you could also call that person an independent facilitator who is allowed to be advocating for an individual in any kinds of circumstances. So I hope that helps, Sonia, a little bit. I'm going to move on just because we only have 2 more minutes of our interpreter to Marta. Marta, go ahead. Marta, are you there? I see your hand is raised. You don't seem to be muted, but I cannot hear you. If Marta is on by her cell phone on our call, she would need to press *6 to unmute herself because I'm trying to find her. I'm asking to unmute.
I've merged her audio, so she should be able to unmute.
Marta, are you there?
Judy, you want me to ask her in Spanish?
Yeah, please.
Señora Marta, Judy está preguntando si usted tiene una pregunta, es el momento de preguntarla.
Can anyone hear a very, it sounds like she is talking, but we can barely hear her.
Yeah.
Yeah.
Lo siento, Marta, no podamos oírle.
Marta, no la escuchamos. Si tiene su pregunta, este es el momento de hacer la pregunta.
I know she's really wanted to ask a question so badly, but maybe I see Carla trying to call her, and maybe you can just be, you can just say it through the phone.
Technology is great, except when it's not.
Yeah, totally agree.
So now speaker, let's see. Can you hear? Habla Marta.
Okay, ¿me oyes?
Yeah, go ahead.
Okay. Quería exponer mi caso porque tengo desde el 2016 pidiendo terapia del habla por una clínica, por necesidad médica. La pediatra me está recomendando desde el 2016 que mi hija reciba esta terapia tan importante para ella, pero no encuentro un lugar porque ella tiene medical directo. Entonces decidí pedírselo al centro regional y el centro regional me pide una carta de negación por parte del medical, pero no tengo esa negación porque el medical no me lo está negando, sino que me está mandando a otros proveedores que no aceptan el medical directo. El centro regional, decidí pedírselo al centro regional, me lo negó, y el señor César García me dijo que en el Children's Hospital yo encontraba esta terapia. Yo llamé al Children's Hospital y también fue negada. Llamé a UCLA, también fue negada, y al Memorial Hospital también lo negó. No encuentro ya, siento que ya busqué demasiado el recurso genérico, pero el centro regional sigue diciendo que hay un recurso genérico cuando no lo veo en este caso. ¿Cómo voy a obtener eso? ¿Cómo tendré éxito en mi audiencia que se acerca pronto?
Okay, I'm going to cut off just because that was a very long question and that's a lot for Lorna to interpret.
I have been requesting for speech therapy for my daughter since 2016 due to medical need. That's what my podiatrist had recommended for my daughter, and I just can't seem to find a provider. My daughter has a standard medical, but I have not been able to find an appropriate provider through a generic service. So that's why I decided to ask the regional center, but the regional center said that I needed a denial letter from Medi-Cal, but it's not that Medi-Cal is denying me, but Medi-Cal is referring me to providers who do not accept Medi-Cal. So I've been searching for different resources. I've been told Children's Hospital and all these things, and I've been denied. And every time that I tell the regional center, they always said that there is a generic resource available, but they just doesn't seem to be available. So I don't know what to do and what can I do for me to succeed with my case if I go to fair hearing.
Right, and that's where you want to keep good records of, literally I would keep a log of every place that you called, with the date and time you called them, who you spoke with, what they told you, If any of those you can correspond with via email, a lot of those, it may just be able to do phone calls, but if you could do email, so you would have an email chain where they say we don't accept Medi-Cal. If any of their websites clearly state that they don't accept Medi-Cal, I would screenshot those. That's the kind of evidence that you're going to use to show you've tried to exhaust your generic resource. You know, you've done everything you can to access your generic, and there's nothing left for you to do. Therefore, regional center as a payer of last resort now needs to come in and pick that up, even though it's something typically a generic would do. Yeah.
Great, thank you. I hope she was able to hear that interpretation.
I think Lorna's still, I tend to talk too long for interpreters. Sorry, Lorna.
She's interpreting simultaneously through the Spanish back line. So I'm hoping that Marta.
Yeah, we got back on.
Marta?
Sí, sí le entendí.
¿Tenés alguna pregunta de respuesta o algo así?
Pues nomás quería saber cómo, si, o sea, me están haciendo las cosas muy, muy difíciles, estresante desde el 2016 y todavía no quieren acceder a dar esta terapia. Sin embargo, me mandan al distrito, pero el distrito es muy diferente, es para su educación y yo busco algo de la comunidad. Entonces, ¿pueden negarme eso mandándome el distrito con el distrito nuevamente?
Yeah, and so also distinguishing that the school is not a generic.
Okay, so
it's, you know, I think you use the same sorts of strategies where you're going to document that the school, what the school is offering is different than what this need is. It doesn't meet this need. And so that's part of that documentation. And right now, because of COVID, the school may be doing nothing, honestly, to work on her speech. So it is even more necessary.
So I unfortunately need to cut us because Lorna needs to go. I need to go and finish this grant proposal. Katie needs to go and walk her dogs. So I want to thank you so much, Katie, for that great presentation. We promise within a couple of days, we'll have it up on our Interchange website. Please use our Interchange website. That's why we built it, for you to use. And we thank everybody. I hope to see you all at this really great webinar that we're having tomorrow on for Disability Vote California. Take care, everybody. Stay safe. Stay indoors. Bye.
Bye, everybody. Thank you.